It's such a pleasure for me to come here and speak to all of you today on career on alternative dispute resolution. Um, I will share my experiences and also guide you with regard to how you should take this particular practice as part of your future journey as a lawyer, because ultimately you have a lot of options, but which one to select, and we are asked many times, is that what do we do when we pass out from the law school, whether we should do corporate law, disputes, and arbitration, and all are good. It depends on your choice how you want to do it. I was very clear that I wanted to specialize in arbitration, so I shifted my base from Ahmedabad. I'm born and brought up in Ahmedabad, did my schooling here, and I did my law from Pune, and then I did my master's from London School of Economics in arbitration, and shifted my base to Delhi, because in those days Delhi and Mumbai used to be the prime place for international arbitrations in India, at least 20 years back. So now we see a lot of arbitration happening in Gujarat also. Yesterday I did two, today I have two arbitrations in the evening in Ahmedabad. So arbitration has a lot of options. I'll take you through what are the various concept of alternative dispute resolution and arbitration, mediation, and conciliation. There are various other aspects of dispute resolution mechanism. Then I'm sure you will have a lot of questions on what is the difference between them, and also what it entails for you and how you get involved with those aspects of dispute resolution mechanisms. Now, dispute is inevitable. Any commercial transaction you have, you will have a dispute, because that's an evergreen thing. There was a recession in 2008. During COVID, also we had so many disputes because people have problems, then the dispute arise. If everything is fine, it's a developed economy, you won't find that many disputes. But in developing economy, you see a lot of development in terms of infrastructure. We have huge construction projects going on, new airports coming, new highways coming, then you have the contractors, and then there are multiple contracts on construction. You see quite a bit of disputes on that. I'll also talk about various types of alternative dispute resolution and where arbitration can be a very effective tool to resolve these disputes, and why our court systems are not equipped to handle those kind of disputes. We will also talk about how to qualify and what are the qualifications required for specializing in this particular field of law, which will help you to compete with your peers in the same field, because every year thousands of lawyers are passing out from various law schools across India and abroad. So you are competing with also lawyers who are doing arbitrations outside India, because if you are talking about international commercial arbitration, invariably you will have lawyers involved from other jurisdictions as well. And clients are very smart now. They want the best. They want expertise. They want specialization, and they want the knowledge of that particular field before they select you as their counsel or a trusted advisor. Because unless and until you know the subject, you have the skill set, they are not going to bet on you for their multi-million-dollar disputes, and that's a life and death for them. So ultimately, it's like in criminal jurisprudence, you have personal liberties involved. Here the business is dependent on the disputes, and we have seen our experience. If you get it wrong, the entire business can be wiped off if you don't get the disputes rights. We have seen that in our experience. Also, there are a lot of pathways when you talk about ADR. You can be a lawyer, you can be an arbitrator, you can be an in-house counsel. Now, a lot of companies are having their legal departments headed by eminent lawyers who have practiced as a law firm partners, or you start as a junior counsel in the company itself. That is also a very good way to consider how to specialize in this particular field. I understand we have a mixed crowd. We have students from all stages of law. So I'll make it mixed. Some of you may know the concepts, some of you may not know the concepts. So I'll start with the basics. So those who know, it will be revision for you. Those who don't know, it will be interesting for you to know what are the various types of dispute resolution mechanisms. So in India, we have the court system. The courts are the default dispute resolution mechanism. The courts get jurisdiction from either the defendant who is residing or carrying on business in the jurisdiction of that particular court, or where the cause of action arises for that particular dispute. So that is the jurisdiction. Arbitration takes away the jurisdiction of the court by way of an agreement to arbitrate their dispute, and only certain kinds of dispute can be arbitrated. And there is a concept of arbitrability, which also we will discuss briefly. Apart from that, we have specialized tribunals. So sector-specific tribunal, for example, in competition law, we have the Competition Commission of India and National Company Law Tribunal. For shareholders dispute, you have also the National Company Law Tribunal. We have, for consumer disputes, we have the consumer redressal forums and commissions. Then we have IBC also, in bankruptcy court, insolvency and bankruptcy court. We have NCLT as the court. For securities disputes, you have a securities appellate tribunal. So in India, we have got these specialized tribunals. And there are many lawyers who specialize before these tribunals also, and they make very good practice out of it, because there also you need to be consistent and have the knowledge of the subject as well as the procedure. So that is also a very good option for you to specialize in particular field. When we talk to students who want to join the law firm, or they want to join the profession, what we understand is they are very focused. And if you are focused from your early days, it helps you to specialize over a period of time. My suggestion would be that you start doing everything for a couple of years. If you want to do masters, you can do masters after a couple of years or immediately after your law. If not, then you can join a particular field which is liking to you. And it takes time. Internships really help you to decide where your interest is, or the subjects which you are being taught here can also help you to decide what to do. But if you decide to do alternative dispute resolution, there is a huge scope. And that scope is going to continue at least for another 20-30 years. I can be very sure about that. That ADR has evolved as a very good practice area for the lawyers, because you can also become the arbitrator. Normally, to become a judge, it is a very long process. You have to either give exam for lower judiciary, for the High Court and the Supreme Court. There is a selection process. But as an arbitrator, you are doing the same job of a judge, because you are deciding a commercial dispute in a very confidential environment, and you know the process. I know as of now we are appointing a lot of former judges as the arbitrators, but the days are coming there we want to appoint more and more lawyers and the specialist arbitrators who have not had the experience of sitting as the judges of various courts. So that is also future. I'll talk about that as well. Now let us start with the concept of ADR. What is ADR? Some of you may not have been exposed to the arbitration because you have just joined law in last year or this year. So maybe you may be new to the concept of arbitration and mediation. Now ADR, as the name suggests, is an alternative to the traditional process of dispute resolution before the courts. It is a very wide array of practices which are directed towards the cost-effective, quick, and final resolution of the dispute. Now, all these are very important, because in commercial transaction, when you are entering into a contract with somebody to perform certain aspect of your job, or a purpose for which you are entering the contract, you want a finality of the performance under the contract. You don't want your children or grandchildren to get the benefit of that particular contract, because you have to move on with the life. If you want to construct a building and you engage a contractor, you would want the building to be constructed so that your classes can start and you can start using that building. If it takes 20 years to resolve a dispute, you will never be able to enjoy that. Even if you win after 20 years, is of no use, because you may save a lot of cost in waiting for those 20 years. But see the benefit you are getting by completing that dispute either this way or that way, and then moving on with the life. So that is where the advantage lies, is that it is very quick, It is cost effective in that sense. Sometimes people also criticize that the arbitrators charge very heavy fees, and lawyers also charge very heavy fees for arbitrations. But you see, the result is coming in a very short time. And short time, I'm comparing with the courts, not with like you get it within 6 months or so. Also, if there is only document only arbitration. But even if otherwise, if we see within 1 year to 2 years, we see the results coming from the arbitration. Also, party autonomy. Party autonomy is very important for arbitration, because you get, as a party, or if you are representing a party, you get complete control of the process. Here, when you go to the courts, you have the Code of Civil Procedure, Evidence Act, applicable to the commercial disputes. You have commercial courts, so the judges are appointed by the process which is followed in the appointment. Here you can appoint the arbitrator. Here you can tell the arbitrator which rules to follow, and the arbitrator is bound, because arbitrator is a creation of a contract. Without contract or agreement to arbitrate, there is no arbitration. So therefore, party autonomy is very important. Confidentiality. Nobody knows what is happening in the arbitration. There is now confidentiality obligation also in our act, which says that all the lawyers, arbitrators, and everybody involved with the arbitration process will maintain confidentiality. Now, growth of ADR in India, we have seen India has promoted ADR a lot in terms of legislation, the judicial pronouncement. You see number of court decisions which promote arbitration. Earlier, when we started the practice of arbitration, courts were interfering in the process of arbitration a lot. But now, over a period of time, judges have also realized that arbitrators should be left to decide the disputes finally, without getting into the process of arbitration at the stage when the arbitration is going on. Even after the award comes, the grounds for challenging the awards are very, very limited. So the courts have been promoting arbitrations, and Indian courts have adopted a pro-arbitration approach. There are a series of judgments of the Supreme Court of India which really indicate that the courts are very conscious that the arbitrators should be given full power to decide the dispute without interference from the court. And that is where we are lacking in India. We need to ensure that the process of arbitration is followed properly, the awards are well reasoned, and therefore there is no need to go to court at all. Even for appointment of an arbitrator, either the parties can agree to appoint the arbitrator, or you can go to arbitral institutions. And I'll talk about institutional arbitration. Most of our arbitrations are ad hoc arbitrations. Ad hoc arbitrations are conducted under the Arbitration and Conciliation Act without reference to any particular institution. Now, institutions are very popular in other jurisdictions. In India also, we have several arbitral institutions. They provide the services of administration of arbitration. So those are the institutions. They have their own rules, and those rules can be adopted into the arbitration agreement by referring to those rules. So it is incorporated by way of a reference into the arbitration clause itself. Now, arbitration can be in a clause in a contract, but it is a separate agreement within an agreement. So you see that a severability concept is also there in terms of arbitration. So even though your contract is not valid, arbitration agreement can still survive, because that is the beauty of the arbitration, is that even though your main contract is held to be invalid, the arbitration agreement still survives. So those are the advantages of going for arbitration. If we see what kinds of dispute can be referred to arbitration, these are the various examples of the disputes which can be referred to arbitration, which are mostly commercial in nature. You can't refer matrimonial or your disputes with regard to trust act or guardianship or those kind of issues, because there is a concept of right in rem and right in personam. Right in personam is between two parties. Only the parties to the arbitration can be referred to arbitration. So the examples of arbitrable disputes are shareholders disputes. When you purchase shares in a company, you enter into shareholders agreement, and those shareholders can have the disputes which can be resolved by way of an arbitration. The major category of the disputes which we see in arbitration is construction and infrastructure disputes. Number of construction contracts are entered across India, and there are many the foreign construction experts are also coming to India to construct various projects in India. They have public sector undertakings in India are entering into the contracts for construction of highways, power plants, dams. I'm doing a lot of arbitrations for NHPC or IRCON. Those are the NHAI. Those are the public sector undertakings where we deal into a lot of kind of construction projects, and we have to understand how the construction happens, because when you argue before the arbitral tribunal or you sit as an arbitrator, you need to understand the sector as well. Now, lease disputes are also earlier was not arbitrable, but after the decision of the Supreme Court, now lease disputes are also arbitrable. Maritime disputes, a lot of ship building contracts, or the contract where the goods are transferred from one country to the other through the sea, those disputes are also referred to arbitration. Apart from that, we have franchising agreement, joint venture agreement. Oil and gas, again, is a very big field where we see the arbitration happening, where you have a joint operating agreement, production sharing contracts. All these disputes can be referred to arbitration. So it's a huge field of arbitration where different kinds of projects and contracts can have an arbitration agreement where you can refer the disputes to arbitration. Now, what are the different ADR mechanisms? I have spoken about arbitration a lot, but that's not the only one. You have negotiations, good faith negotiations, expert determination, arbitration, mediation, conciliation. These are the various means of alternative dispute resolutions. And since arbitration is most popular, why? Because it is an adjudicatory process where one party wins and the other party loses. Whereas in mediation, both parties come together. It's a different skill set where the mediators brings the parties together, and they can resolve the disputes among themselves by negotiated settlement, which is also binding between the parties. Now, if we talk about the advantages of the arbitration, now arbitration brings the speed, it reduces the cost, it gives you the choice of arbitrators, it also gives you the flexible procedure. Award is executed as a decree of the court, so you don't have to go to court and re-agitate the same issue. The court will accept the award as a final decree of that particular court and enforce it. It is as if it's a decree of the court. Then we have the limited grounds to challenge and the confidentiality. So these are the advantages of arbitration. Mediation, on the other hand, also provides a very good way to resolve dispute. Now, last year we have come up with Mediation Act, which is very helpful to codify the concept of mediation. Up till now, mediation was not part of any legislation. It was done without any legislative framework. So now we have the legislative framework where mediation is defined. We have also defined what kind of disputes can be mediated. We have also defined who is mediation service provider and how the mediated settlement can be enforced. So all this is provided under the Mediation Act. The mediator is appointed by the parties or by the institution. The institution mediation can take place. There are various institutions like Singapore Mediation Center is there, SIAC, ICC. There is also concept of hybrid dispute resolution, which is ARB-MED, ARB or MED-ARB-MED. Now this concept is very new and unique, where you know that one kind of dispute cannot be resolved by one particular way of mechanism of ADR. So just to give an example, we had a shareholders dispute. So we went to London, we had a 5-day hearing there, and then we tried to mediate. So what happened is that we started with the arbitration, then we stopped the arbitration saying that let us try to mediate. Then a mediator was appointed who was not the arbitrator. And the mediator tried to see that where are the differences. And after deciding that, the parties agreed that yes, we will pay. That means the liability was agreed, but they were not agreeing on the amount, that is the quantification. How much we will pay was not agreed. We will pay was agreed. So the other side said yes, they will pay to our client, but how much is to be determined by the arbitrator. So half dispute was resolved by mediation, half dispute was resolved by arbitrator, where the arbitrator decided the quantum and the liability was agreed between the parties after the mediation. So that helps to resolve the dispute. The cost was half. Even the time was reduced to almost half when it came to mediation. Now, conciliation is very similar to mediation. Conciliation is covered by Part 3 of our Arbitration and Conciliation Act of 1996. Now, after the Mediation Act is enacted and which will be notified with the rules in near future, the Part 3 will be deleted from Arbitration Act, and mediation and conciliation will be treated as one and the same. When I appeared before the Joint Parliamentary Committee, we said there is slight difference between mediation and conciliation. With conciliation, the conciliator plays a very different role than a mediator. As a concept, conciliation is different, but somehow our Mediation Act has defined the conciliation as an inclusive, or mediation as an inclusive of conciliation. Therefore, we will be deleting our conciliation part from our Arbitration Act. And then we will have Arbitration Act and a Mediation Act. So these are the two major fields. Now, as far as mediation is concerned, if you want to become a mediator, you need to have a training as a mediator. When we train our mediators in various institutions, there are role plays where you are acting as a party nominee or as a mediator, and you decide the dispute, or not decide, but you help the parties to resolve their dispute by way of a mediated settlement. So it's a very different skill set than the arbitrator, but it's also going to be very effective in years to come, because more and more parties are realizing the value of mediation as compared to arbitration, and they are going to use mediation also as a process for arbitration. Now, what is important to, what are the skill set required for become an arbitrator or arbitration practitioners? You need to have the subject matter knowledge. Therefore, for knowledge of Arbitration Act is very important. So you must know all the provisions of our Arbitration and Conciliation Act, because that is very important for you to understand the process of arbitration, because there are two types of provisions in our Arbitration Act. One is mandatory and other is non-mandatory. So some of the sections, if you see our Arbitration Act, it says unless otherwise agreed between the parties. So those are derogable provisions where the parties can agree contrary to the statute. So arbitration is a unique statute which gives the parties power to agree first, and if they don't agree, then the provisions of law will apply. So party has full control over the process of arbitration, and there are sections in our Arbitration Act. It says that the arbitrators and the parties will decide the entire procedure. In addition to this, the ADR practitioners are also expected to have conceptual knowledge of various arbitration law and also the contract law. So if you want to specialize in arbitration, you must also know your basics into the contract law. Also, the Evidence Act doesn't apply, but the way of proving any particular fact remains the same. So how to prove a particular fact before the arbitrator? Specific relief act is also frequently used when you are asking for damages or asking for specific relief. And also your other procedural aspect of production of documents, proving of documents, all these aspects are very necessary when you want to specialize in arbitration. Now, successful ADR practitioners must also aware about the international conventions. So, for example, you want to specialize in arbitration and doing arbitration in Singapore, you would also need to know the Singapore Arbitration Act, because your seat of arbitration is in Singapore. If you have a foreign award passed outside India, you want to enforce it in India, you would also need to know New York Convention. Now, our Part 2 of our Arbitration Act deals with the New York Convention and Geneva Convention, where in those countries which are signatory to those New York Convention, and if it's a reciprocating territory where they are recognizing our awards, we will also recognize their award. As of now, 44 countries are notified by central government as a reciprocating territory in the New York Convention. Any award passed in that country will be treated as an award passed by Indian court and will be enforced as if it's an. So those knowledge is also that knowledge is important for us to know international conventions, ancestral rules, and many other jurisprudence with regard to the arbitration is very important. Further, it is important to stay abreast with the recent judgments, because the arbitration is an evolving practice. So what you need to know is that what is the latest judgment of the High Court or the Supreme Court in various parts of country where various High Courts are there, or the Supreme Court is a final authority. on the decision in India. So we need to know the latest judgment. So you have to keep reading and keep writing about this particular subject. When you write or when you speak on a any particular subject, you have to prepare, and that preparation is very helpful. So you have to keep reading and writing about this subject. That will also help you to be differentiated from your peers, because you have to stand out if you want to practice a particular field, and then only you will be accepted by any law firm or any good office, or the client will approach you for those kind of matters. You should be known, and how do you get known in a particular field is by knowing the recent developments and also sharing your knowledge with others. Now, also understand how to go for enforcement of the arbitration uh, awards, and also emergency arbitration is a concept which has developed abroad, and now in India also we have recognized that through the judicial pronouncement. We wanted to amend our act. Now, emergency arbitrator is an arbitrator appointed only to decide an interim relief application before the arbitration starts. So that is also a new concept. You must be aware of it. You must be aware of the chess clock method. Now, what is chess clock method? In an arbitration, in international arbitration, we know exactly which party is going to get what time. It's fixed time given. So we prepare for 3 hours. We study for 3 days. It's not like we just go and argue anything, because everything is calculated. Whatever we speak is recorded in live transcript. So when we go for international arbitration, a screen is given in front of you. Whatever we are speaking, there is a live transcript of what is it? There is a record, and you can go back on the record and check that what you argued, and you cannot change your position also. Many times when we make oral arguments, we argue something and then we improve it later on, but that is not possible in arbitration. So you need to be fully prepared to conduct those kind of arbitrations. Of course, in India, we have not followed that very strictly. In some arbitrations we do, some we don't. So we goal is to achieve that level so that we reduce the time and cost. Yes, there is an additional cost of transcript, but see, the value it brings is that you don't speak anything what is not necessary to be spoken. You prepare well, and then you know that everything is going to get recorded. Also, the concept of arbitrability, what kind of disputes can be arbitrated, not arbitrated, you must know. And also interplay between Arbitration Act and other statute, which is very important for us to understand as the arbitration. For example, Commercial Courts Act. Now, Commercial Court Act also provides that which is the court which will have jurisdiction over the arbitration dispute. So if there is a pecuniary jurisdiction of that particular court, we must know where to file your Section 9 petition. For example, for interim relief, you must know where the court is, where the seat is, and all those aspects you must know, because your filing or drafting skills will depend on which court you are appearing, because every court has a different style of presentation, so you must know. Many courts require you to file separate application per prayer. The affidavit has to be signed in a particular way. So as a lawyers, we must know all this. As young lawyers, I also used to do it like 15, 20 years now. My colleagues do those aspects of filing and other aspects, which is very important for us to know as young lawyers, is that we must know the court and the procedure of the court, because arbitration, if you do arbitration, the court invariably gets involved at one stage or the other. Maybe at the appointment of the arbitrator, or to grant interim relief, challenging the awards, enforcement of award. These are the types of reliefs you would ask from the court, even though you have an arbitration agreement. CPC is important to you must be aware about CPC. Why? Because when you go to court, CPC applies. So whenever the court proceedings are there, as per Section 5, it says that the court will exercise jurisdiction only specific provisions which are provided under the Arbitration Act and not otherwise. Mediation Act, as I narrated, now gives the legal sanctity to the mediation. Mediation was brought in because there was a lot of demand for the act to control the way we do mediation. The aim of Mediation Act is to promote and facilitate mediation in India, especially institutional mediation, for resolution of the commercial disputes. We have seen mediation happening a lot in matrimonial disputes or family disputes, but commercial disputes are required to be mediated a lot than more what we are doing right now, and we should aim to specialize in mediation. All of you should consider a career in mediation as well, because that is going to be also a next big thing when it comes to alternative dispute resolution. Now, pre-litigation mediation is compulsory under laws. If there is no arbitration, we may have we have to go to mediation before we file a suit. In many of our arbitration agreement also, we have a multi-tiered dispute resolution mechanism where you start with the mediation and then go to arbitration. You start with a less formal process, that is mediation, and then go to more formal process, which is arbitration. Again, that is something I've explained, that there is a tiered approach or a hybrid approach. Tiered approach is one after the other. Hybrid approach is that you start with one, go to the other, and come back to the first one if you are not successful in the second one. So that is the approach we have followed in number of disputes, and that will also help you to have a multifaceted experience in resolving disputes through various ADR mechanisms. Now, what are the technical skills you must have, or as an arbitrator or a counsel who is practicing in the arbitration field, you should develop? The first and foremost is strategy, because everything revolves around the strategy. So if you don't have the strategy in place, you won't be able to advise the client in a way that the client wins. Every client wants to win. So to make that party win, you need to strategize from the beginning. You must know what is the ultimate goal. What are the weaknesses of your case and what are the strengths of your case, and you should strategize from the beginning. Drafting is very important. Half battle is won if you have good drafting skills, because arbitrators read. Arbitrators read. When we go to London or Singapore, we don't tell the arbitrator what the case is. They tell us that we have read everything and please take it, that each and every document you have filed, we have read it. And there is a fees which is charged by them, maybe as part of their entire fee they have to read, or otherwise in arbitrations where we have per hour fees, we also have reading fees which is separate, where they're supposed to read and come. In our Indian context, many times we pay reading fees but they don't read it. That's a separate issue. But internationally, we see all the arbitrators are very well read. So advocacy skills or the drafting skills is very, very important. Analysis, you have to analyze what is the issue and then come to the particular findings. So you need to go deep into the documents, read the documents and understand what is the implication of that document. Sometimes we see that a document refers to the other letter, but that letter is not on record. Then we keep searching for that letter and the client says that letter is not there, and then the whole argument gets diluted because you don't have the complete chain of documentation. Again, list of dates are very important for any matter which has complex, because we have seen why we go to arbitration, because for two reasons. One is, if you have a cross-border transaction, nobody wants to trust the judicial system of each other. If you have a contract with a UK party or a US party, you would not like to go to US and litigate, and US party would not like to come to India and litigate. So arbitration is a natural forum for them to resolve their dispute. Second is voluminous documents. You have so many documents in arbitration. Sometimes we need to, we can't even print. We have the pen drives or we have the drives where we store all these documents and go through it. It's very difficult for us to even carry those documents unless, earlier it used to be that we used to use that smaller print to print those documents, but now we use technology. We use the soft copies and try to reduce also printing as much as possible. So technology has helped a lot, and you must be also very well versed with using the technology. Online document management is very crucial for big arbitrations, and the court system is not equipped to handle this kind of disputes where you have thousands of documents involved in one particular arbitration. Then next is research. All of you are expert in your research skills. You are trying your best whenever you write an article or prepare for a paper, you do research, but this is a lifelong skill. You need to know that what is the law which is relating to the facts. In arbitration is all about facts. The law is very limited because the facts have to be proven first before even you go to the law. But law is very important. The other problem which we face is that because the arbitration is confidential, we don't have awards which are published. In some of the institutions, they have started with redaction of the award. So they remove the names of the parties and the confidential information and they publish the award. So the jurisprudence on arbitration awards is very, very less. So we rely upon the court's decision where the awards go up to the High Court or Supreme Court and they decide how to deal with those legal concepts. But research is very important. And oral advocacy. Oral advocacy is the key for success in arbitration. So you must be very good in your presentation skills because you are not standing and arguing. You are sitting across the table and talking. So you need to be very soft, very gentle. You can't raise your voice. There are many times senior counsels come from the court and start shouting at the arbitrators. They don't like it because you are sitting across the table and you can't shout at each other. So those are different skills because when you're standing and arguing is different, but when you're sitting and arguing, you have to be very precise. You must be very professional and very polite in the arbitration proceedings. You can't show your court crafts in the arbitration skills because it's a completely different skill set. What is advocacy skills? Advocacy skills is know your audience. Who is your arbitrator? Many times we have seen that the arbitrators come from a very different jurisdiction. Sometimes an arbitrator comes from Germany who has no knowledge about common law or codified law. They come from a civil law background. There are some arbitrators who come from Singapore or London. We need to study the background of the arbitrator also and understand how to present your case before the arbitrator. If the arbitrator is a former judge, then you argue differently. If you are a practicing lawyer, you argue differently. The facts remain the same. I'm only talking about the skill set which you need to develop over a period of time. Effective communication, oral, written, and both has to be effective. You have to be very precise. You can't go and draft very lengthy pleadings in arbitration. I remember in one London arbitration, I started with a draft of 90 pages and to reduce it to 30 pages, I took 30 days. It's not easy to reduce number of pages. It's very easy to write long, but it's very difficult to write short and cover all the points. So that is a skill set which comes over a period of time. When you keep drafting and keep practicing on your drafts, you have to keep reviewing your drafts, then only you can reduce the length and be more impactful then, because there is an attention span which is very limited. If you can't communicate in 30-40 pages, you can never communicate in 100 pages. Although sometimes you have necessity to write more, you can have annexures which will be by way of a list of dates or a PowerPoint presentation. We also use a lot of demonstratives. We use PowerPoint presentation. We use videos to explain the arbitrators. In one arbitration, we had to explain how the tunnel is constructed in Jammu and Kashmir. We had to show the videos as how it is actually done. When I was doing one oil and gas arbitration, I went to the rig and understood how the drilling is done and how you can cap the well and how the cement is poured in the well so that the well is plugged. Unless and until you know the terminology of your contract, you will not be able to successfully argue before the arbitrators. So this is a very different skill set you have to develop. You must know your client, you know the sector, you know the terms of that particular sector, and then present your case before the arbitrators, because ultimately the analysis in the award is more of a fact than the law. Law obviously comes at the end after the reasoning, because all awards have to be reasoned award. As per our requirement, unless the parties agree, all awards have to be reasoned award, and therefore to help the arbitrator to arrive at those reasons, we must present the case very well. And when you sit as an arbitrator, ultimately, you must also keep it in mind that you have to take into consideration each and every argument in a structured way, and then also give reasons for either accepting or rejecting those arguments. So therefore, the structured common sense approach is the best for any arbitration, rather than going into very complex and making it complicated. So what are the other skill sets? So the qualities of an arbitrator or an arbitration practitioner is that you have to be very, very diligent. Whatever you are doing, you must be on top of what you are doing. Also, experience counts. So consistency matters. You have to do the same thing again and again over a period of time. Then the experience makes you expert. Also, knowledge. You have to keep yourself updated on the knowledge of the field which you are choosing. And it is true for every field of law which you are doing. This is not specific to arbitration. This is common for all. And more so for arbitration. Why? Because ultimately these are the things you will actually use. In courts, you get limited time. You get half an hour, 30 minutes. But to continue in an argument for 5 hours, it is not easy. Believe me, I have done 5 hours arguments before arbitrators, and they are very senior, seasoned people who have read your case. To sustain for 5 hours continuously, it's not easy. So you need to have a knowledge of your facts and the law, and be ready to argue for a long time, because because there are 100 cases listed in a particular day, you will not get 5 hours ever in a court. I've never ever argued unless and until it's for final hearing and all the other cases are adjourned. You don't get that kind of time. Whereas in arbitration is given, you have to argue till you finish. So that time is fixed for you. Also, temperament has to be very patient. You have to understand your client, you need to understand the arbitrator, you need to understand how to deal with a particular thing. Any aggressive or impatient behavior will not help you in a long run. Also, you have to also keep in mind that overly argumentative in arbitration, most of the things are agreed, and that's what sometimes the foreign lawyers or the foreign arbitrators find fault with us, that we object. Indians have a habit to object to everything. Sometimes we also object to the video conference. In one arbitration, we found it very strange that before COVID, of course, other side objected to the video conferencing, and the arbitrator agreed with that, saying that yes, if the one party is objecting, I can't force you to do video conferencing. Then COVID came, and I got an email from arbitrator that can we do it by video conferencing. I said, what happened to that objection? He said, no, now it's all fine because everybody is doing video conferencing. So those are the habits we need to give up when we do arbitrations, is not to object to little things, focus on the real issues rather than the small things. And that is very important for developing the skill set as an arbitration practitioner. Now that is all about skill set, but how do you get into this particular field? You need to have qualifications. Of course, you will get a degree from all the prestigious universities like this one, and you will become a lawyer. But is that sufficient? The answer is yes and no both. Yes, why? Because if you get lucky and to get work experience in arbitration, you will develop those skill sets. But if you really want to focus, what all you will do? So one is that you should do every course, additional course while you are in the law school. There are a lot of courses for students in this field of ADR. You should do the certificate course. Even during your internship, you should select the law firms or the lawyers who are doing arbitrations. Also become the student member of all the institutions. There are young student groups, like for example, Chartered Institute of Arbitrator is a London-based, UK-based institution which is mainly into accreditation of the students, practitioners and arbitrators, and also training. So you should do training of those. There is a student membership which is free. For all the students, it is free membership. You get the benefit. You go to the CIR website and type student membership. You can become a student member of Chartered Institute of Arbitrators, and once you become lawyer, you can also enroll yourself as a member and then become a fellow of this CIR. Now, fellowship is very highest level of CIR, and that helps. For example, there is a requirement for empanelment in any particular institution. If you go to, say, SIAC, Singapore International Arbitration Center, they give you, if you are a fellow, you are most welcome. So your first hurdle is crossed. So you immediately get recognition. For example, I can write FCIAB after my name. So I write my name and then say Fellow of Chartered Institute of Arbitrator. There's instant recognition or connect where people know what is the value of it. Also, there are a lot of communities, blogs. You should keep yourself updated on that. Tracking of the global developments, how the global development is happening in the field of arbitration. There are various websites. Kluwer blog is there. There is a lot of reports which are coming from various law firms and universities. You should keep yourself aware of. And also courses. If you want to go for your masters, you should keep it in mind what courses you should take and start tracking from now, so that when the time comes, you are able to make the right decision. As I said, there are a lot of practical courses, seminars. We should be part of it. Professional training is important. Student competitions. There are moots in arbitrations. I'm sure all of you know that. But moots are very helpful when we select students for joining the firm. We also ask them how many moots you have done and what was your performance. It's not about winning or losing. It's just participating is more important than winning or losing any moot. So your experience counts, not the success in any competition. That is very important. And as I said, keep writing wherever you get an opportunity to write. In any of these journals, articles, you should write, and higher studies is helpful. Many students say no, work experience is good enough. I agree with those students also, those lawyers also. But if you can have afford or have time, or you get a scholarship, you should definitely try and do higher studies, because it changes your perspective. You don't know what changes our broad higher studies can bring to you, but others will know. So it is always good to go for it if you can, but it's not compulsory. You can definitely choose. There are a lot of good higher courses are there in India as well. You don't have to always go abroad. But when you go abroad, you meet a lot of other students from the same field, and you can interact and make lifelong relationship with them and understand their culture and their way of studying also, which is very, very important for us to. It is helpful if you are looking at developing your international career. Now, what is the role of law firms or independent practitioners in ADR? Law firms, many times we are asked, what are the qualities to join a law firm? And of course, we see that you must be focused, you must be dedicated, you must know your subject very well. If you say that I want to specialize in this particular field over a period of time, not from day one, at least some basic knowledge about this law is necessary. Plus, we also see the drafting skills, that you must have drafted something, some articles. We see that, because what is the role of law firms in this particular field? So the first is review of documents. We need the due diligence before we start any case. So we involve our team to go through all the documents, then assessing the client's case. So the assessment of the case, what are the strengths and weaknesses of the then devising the strategy, then also preparing the case. So we need to compile. They just dump the document on us. We need to understand which are the documents we are going to file along with our case, and which are the documents which are not relevant for the case. So that is very important aspect. That is the role we ascribe to our young lawyers. And then also research, which is very important, that we want our young lawyers to do research, because ultimately they are the people who will become partner and decide the strategy. So you must know exactly what to find, where to find, and how relevant it is. Many times we are thrown with number of cases which are not at all relevant, and it's a waste of time. So you must develop that skill set from now. Briefing also is very important, because when we grow in the profession, we don't have the time, because we are doing hundreds of cases at a given point of time. So the younger lawyers also should be able to know the pages or briefing. Sometimes we say, okay, where is this thing, and they just keep searching. So that's not good for us, because we don't have that kind of time while we are arguing the case. So you must have the mastery over the facts and also the pages, and organize everything in a particular system where you can find for yourself. You may have your own style of doing things, but ultimately what it matters is whether you can deliver on time. Also, preparing the briefing notes, briefing the senior counsels or the senior partners in the firm, and also ready to argue, because many times what we see is that an opportunity is given to the young lawyers, they are not ready, and some lawyers are very smart and they grab the opportunity, and over a period of time they start arguing cases. So you should be always ready to argue if an opportunity is given. And believe me, those opportunities come which you don't even expect, and then if you take that opportunity, there is always an appreciation for that. I said about in-house counsels. In-house counsels play a very important role nowadays. Earlier, we used to deal with the clients. Clients are the promoters or the business people who only want the result. But now we have seen all the multinationals, all Indian big companies have legal department, and this legal department is comprising of the lawyers who are coming from the big law schools like this, or the individual lawyers, or a law firm partners or the law firm practitioners who have worked in past. So either you can start in-house from the beginning itself, or you can work in the independent practice or a law firm practice, and then also join the in-house role. Now, in-house role is also very important, because you are also involved in drafting. So when you are drafting contracts, you must know what kind of dispute resolution clause you should put for your company, because you are part of that company, you are an employee of that company, so you need to protect the interest of that company. Also, advising the company's management is to how to choose a lawyer or how to choose an arbitrator. So you are the decision maker, you are the king who is the, because we always call client is the king. So if you are a client and you are representing a client as an in-house counsel, you would decide which law firm to select, which lawyer to select, which senior counsel to select. You have a lot of powers, and the final authority given is also to approve bills. So we really respect the in-house lawyers, because ultimately if they don't approve the bills, you don't get paid. So that is very important role when it comes to the lawyering. Yes, there is a lot of coordination there, and many times the lawyers don't enjoy that much, but also it brings you a lot of work-life balance, because in your law firm you don't get that kind of work-life balance. You have to work long hours and be ready to be available 24/7. Of course, we have breaks in between, but not always. So you have to find time for yourself. Whereas in in-house role, there is a fixed time of for your employment, and you then spend a lot of personal time as well. So this is a personal choice you can make, whether you want to become in-house counsel or a law firm practitioner or an independent practitioner, or ultimately become arbitrator or a mediator. But those are the options available to you. There are a lot of options in the field of ADR. I've explained to you, because even as an in-house counsel, you are heavily involved in reviewing the drafts, because we always send the drafts to the clients before filing it. So as an in-house counsel, you have to review the drafts, and also there is a settlement mediation. The clients takes the call. Lawyers can't decide unless lawyers are instructed. So giving instruction is also very important. So the coordination between the management and the lawyers is a very important skill set. Now, if you talk about different pathways, just to summarize what I said, you can become an academician, you can teach also. We have seen a lot of law schools where the lawyers are going abroad and coming back and teaching law, which is again a very good profession if you want to, if you're interested in the academics life, or doing your PhD in law and then becoming doctor in law. That is also a very good practice area. Judiciary is one. Many people aspire to become judges at the young age, or at the age where they can be elevated to the High Court, or sometimes directly to the Supreme Court. Very few, but that is an option. Independent counsel practice, you can join somebody's chamber who is independent counsel and become a junior in the chamber, and then grow and become independent counsel. Law firm is of course an option. In why law firm? Because the big cases go to law firms because of their reputation or their ability to involve number of lawyers at a given point of time. So if the big case comes, the team comprises of 10 lawyers, but an individual lawyer may not have 10 lawyers available at a given point of time to work on one particular matter. So that is a important aspect of a law firm. Again, law firm has a very structured approach. So there is a hierarchy. You start at a young level and then grow. There is a promotion every year if you perform. And also there is a lot of discussion amongst the members of the law firm, because every law firm, if you join a big full service law firm like ours, there are various departments. So even if you are working in an arbitration department or a dispute resolution department, you can interact with people who are doing insolvency. Your friends may be doing capital markets, competition law. Then you have information technology law, tax departments. You have different departments. You can interact with them and grow as a professional by learning from each other. In-house counsel, I have already explained. Mediator, conciliator, or an arbitrator is also a field which immediately it may not be possible, but over a period of time you can really become that. But if you're focused and be ready to develop that skill set. That is the role of okay, this is going yeah, so if you have any questions, I will be very happy to answer. Thank you. Yes.
Sir, am I audible?
Yes, you can.
Good morning, sir.
Good morning.
Sir, the main objective of ADR is to reduce the burden of court.
Yes.
Correct?
Yes.
So, sir, in Gujarat High Court, what I have personally experienced is that on certain days, the Honorable Chief Justice Court needs to take time from 4:30 to 5 to only listen to the matters of arbitration. So, isn't there a lack of some regulations in respect, because it could be like parties maybe
No. So what we are talking about Fridays when the Chief Justice is appointing arbitrators. So those are not arbitration matters or there is no lack of trust. What happens under our law is that if you have to appoint an arbitrator and you fail to appoint an arbitrator within a 30-day period, then you can straight away go to High Court and appoint an arbitrator.
I'm not talking about appointment of arbitrator.
Right.
I'm talking about any such challenge of the arbitral award or any such issue in relation of appointment of arbitrator. So such matters are combined and presented before the Honorable Chief Justice of High Court bench on certain days, wherein the Chief Justice only listens to the matter.
Yeah, it's good, right? Because you are giving priority to those matters, because if those matters are listed on regular days, then you will not even get time to listen to those matters. So therefore, Fridays are assigned in Gujarat High Court to listen to arbitration matters. And that also we are trying to bring. So coming to your question, we are trying to amend the law, and we have already amended. Now, what will happen is that once those amendments are notified, say 2019 amendments are notified, then this power of Chief Justice to review all this will be given to institutions. So you will have institution in Gujarat High Court. There is an arbitration center. There you have a director of arbitration center who would get that power. So if you read section 11, which is amended after 2019, that power will be given to the this thing. So we are reducing the burden. So your point is, how do we reduce the burdens? We are already aware of this. Now, why we are not able to notify it is that we have to, that notification is dependent on establishment of Arbitration Council of India. Now, if you see the amendment of 2019, there is a provision under the amendment to appoint an Arbitration Council of India. And once the Arbitration Council of India is appointed, they will accredit the institutions who will do the appointment. So all your question about why Chief Justice has to spend so much of time and why we are spending so much of time will be taken care of by the arbitral institutions.
Good morning, sir.
Yes.
Actually, I have a question that is generalized to the topic. So the question is, sir, during the course of drafting, while analyzing the case or the matter at hand itself, how do we reset our perception? That is, like when we draft, in the course of that, we clinch to a certain perception. Now, through the course of drafting, if we want to reset our perception during the drafting, then how do we approach it and approach it as fast as possible? Like supposedly you have mentioned that if it took like you around a 30 days duration to reduce the document of 900 pages or 90 pages to pages of 30. So how do we reduce that duration? Any suggestion?
Yes, so definitely you should discuss with your colleagues. That is the first thing, is that if you have somebody in your team who is experienced, you can take guidance from that, show that document to that person and say that, look, this is what it is. What do you think, where I'm going wrong, where I can reset my perception, because my perception is this. Is there am I going wrong? So that's the advantage of working in a team. So teamwork really helps in achieving that. Secondly, also, you have to read a lot of drafts and understand how the drafting is done. So whenever you get an opportunity, we see that lawyers are only focusing on the matters which are assigned to them. But in any particular office, you have number of cases going on, and those cases are not always live. So some there is a duration where there is a next date is after say 1 month, and the team is not working on it. So you can any time request that team and say that, look, can I go through the drafting you are doing? So those are the things which you can learn from your seniors, from your colleagues, and discuss this. Also, now if you ask me to reduce it, I can do it after 20 years of practice in 10 days. So it also, the number of years you spend in profession matters, because as a younger, you will take longer because you have not got experience. But if you keep doing the same thing again and again and again, now today if you ask me, I can do it in 1 hour also. I say you delete this and then do it, because then sometimes people come and say, how are you so fast? I said, no, I was not fast when I started. I've become fast because I kept doing it the same thing again and again. So consistency matters. There is no shortcut. You can't say, no, I want to copy you today. I can never copy Salve or Palkiwala, because I'm not at that level. You will not be at my level. We all have a different paths, and we have to improve every day. You have to compete with yourself every day, and you have to improve every day. And you cannot do the same thing which you were doing 1 year before. You have to do something different, otherwise you are getting stagnated. Then you will not be respected in the profession, you will not grow. If you don't grow, nobody will also work with you, because if you are not growing, you are not allowing others also to grow in your team. Unless and until you vacate the space for your colleagues, you will never be able to grow in the profession. If you have an insecurity, you will always remain the same. And we have those lawyers who have doing the same thing for years, and they are doing the same thing for throughout their life. But we can't become like that, because there is a lot of competition. You will become redundant, because the younger generation will come, will be smarter than you. They know the technology. They will really replace you. Artificial intelligence will replace you. You have LOL chat GPT. Now your drafts are coming from that, and you don't even study more than what you are necessary to study. In our time, we used to study a lot of things by default. I'm searching for one thing, I used to study another 10 cases, but those are not relevant. So how do you know it's not relevant? Only once you read, you will know. Now your search terms will be like that, that you will only find relevant cases. Then you are not even knowing that there are other cases exist in this book or in this journal. You will never come to know. So that is the problem we are facing, is that we are only focusing on what is required. We are only focusing on a limited research, and we are not learning as a part of that research. Many times I have seen that although the case was irrelevant for that particular matter, but because I had read it, I can link it when the same issue arises in some other case. So those are the things which you should do: write articles, read articles where it's researched material, and then over a period of time you will improve and reduce the time.
We have just one last question.
Good afternoon, sir. Thank you so much for the insightful session. And coming to my question, in regards to the emerging trends in area, so as we have arbitration and as you stated that we have a legislation for mediation act as well. So as practitioner, how do you analyze, choose or advise clients whether to go for arbitration, mediation or opt for MEDA?
Yes, very good question. It really depends on the goal of the arbitration or mediation. If there is an ego battle, somebody wants to teach a lesson to somebody, they are not going to mediate, right? But if you think that there is a possibility of mediation where both parties are reasonable, they are open to discuss, you should always give it a try, because mediation is not compulsory. It doesn't closes your doors forever. You can always do arbitration after doing mediation. So there is no harm in trying for mediation. So we always advise the clients to at least give it a try. If it doesn't work, it doesn't work, but therefore you should try for it. There are some cases we don't even advise for mediation, because we know that no matter what you try, it's not going to happen, because the client is telling you, I'm not going to settle this. I want this to achieve. It's not about money, but it's to take a revenge or take a challenge against somebody who has made you suffer, or you have suffered a huge loss, which can't be compensated by any money. So therefore, you have to see the facts of every case and understand whether it will work or not. It can also sometimes we feel that this matter can never be settled, but you don't know what are the emotions of a client or what is at the back of your mind. Sometimes the client interviewing technique is also very, very important. Client counseling is also very important. There are now competitions of negotiation and client counseling where you should participate and understand this concept, because client thinks that something is very important for this case which is absolutely relevant. And sometimes the most crucial information is not shared with you, and then you ask them, but they say, no, but that's not relevant, so I didn't ever think of sharing it. But I said, you should have given it to me. Sometimes that one document can change the course of arbitration. I'll give you a live example. We did a lease dispute where the whole question was about measurement of that particular floor. After that floor, there was a joint measurement conducted. There was a joint minutes prepared. After that minutes were prepared, one of the representative comes to the client, one of the parties, and sends an internal email saying that I attended this joint measurement and these are my observations. Now, this is not a confidential document which is existing in that. Some employee left and then disclosed that letter to the other side, and we won the arbitration on very one email on the admission part. Now, the client never thought of sharing that document because they thought it's not relevant, but it was relevant. At least you must know that this exists so that you are prepared to answer that. So those are the things that clients, you need to know the facts, you need to talk to the clients, understand their case, and therefore the due diligence before you start the case is very important. And those skill sets are very important for you. So depending on the facts, you can suggest whether to go for mediation, arbitration, or both or combination of each other in a sequence where you should go. But you can never start with arbitration. Arbitration always comes at the end. It was my first visit to Karnavati University, and I really enjoyed being part of this university. As soon as I entered, the campus was very, very vibrant, with a lot of fountains. It was very soothing. I interacted with students and really enjoyed interacting with them. They were very, very curious to learn new concepts of ADR, and the questions they asked were also showed their curiosity on the subject, and they wanted to learn and understand this concept of ADR and how to specialize and build a career in the field of alternative dispute resolution. I really enjoyed interacting with them, and I look forward to more opportunities like this.